Hi, Avery once again from Cielo Dei Voluntas. Today, I'm going to break down step by step how reasonable accommodations work for employees with anxiety under California law, and more importantly, how you can request one if you meet it. This is your guide to understanding your rights and taking action. Let's start with the most important question. What is a reasonable accommodation? The answer is in California, a reasonable accommodation refers to any change or adjustment to a job, work environment, or the way tasks are typically performed that enables a qualified individual with a disability to have equal employment opportunities. This concept is grounded in the California Fair Employment and Housing Act, FEHA, which mandates that employers with 5 or more employees provide such accommodations unless doing so would cause undue hardship to the business. And now, what does this mean for you? If you have a disability, whether it's physical or mental, visible or not, and it significantly affects your ability to perform essential job functions, you may be entitled to reasonable accommodations. For instance, conditions like anxiety, which can impact concentration, communication, sleep, or stress management, are recognized under FEHA as protected mental health conditions. Now, let me give you some examples so that you can have a clear idea. Accommodations can vary based on individual needs, but may include number one, modifying work schedules or allowing flexible hours. Two, providing assistive devices or modifying equipment. Three, adjusting job duties or reassigning non essential tasks. Four, allowing remote work or telecommuting options. Number five, offering additional training or support. Sixth, and the last point, providing leave for treatment or recovery. These adjustments aim to ensure that employees with disabilities can perform their jobs effectively and enjoy equal benefits and privileges of employment. Now, let's talk about the process. Here's your step by step guide. Step one, recognize when anxiety is affecting your job. Are you missing deadlines because of panic attacks? Avoiding calls or meetings due to social anxiety? If your mental health is interfering with your work, it's time to think about getting support. Step 2, speak up. You need to let your employer know that you have a health condition that requires an accommodation. You don't need to say, I have anxiety, if you're not comfortable. You can simply say something like, I'm managing a medical condition that's affecting my ability to do parts of my job. I'd like to talk about possible accommodations. This can be a verbal conversation with your manager or HR, or it can be in writing. There's no legal requirement to use specific language or to cite the law. Step 3, be prepared to provide documentation. Your employer may ask for a letter from a medical provider. It doesn't need to go into detail. It just needs to confirm you have a condition that may require accommodation and suggest what kind of help would support you. For example, your therapist might write a note recommending flexible scheduling or periodic breaks to help manage symptoms of anxiety. Step 4, engage in the interactive process. This part is critical. Once your employer knows you need accommodation, they are legally required to engage in what's called an interactive process. It's a conversation, back and forth, where you both explore possible accommodations. And this is where you can explain how specific changes would help. For instance, taking a break after 2 hours of focused work helps me reset when I start feeling overwhelmed. Working in a quieter space allows me to concentrate without getting triggered. Remember, you're not asking to avoid work. You're asking for support to be able to do your job successfully. Step 5, review the response. Your employer should either approve your accommodation or explain why they can't. and they must do this in good faith. They can only deny your request if it creates an undue hardship, meaning it's too expensive, disrupts operations, or isn't reasonable for the business to implement. But they can't deny you just because they're unfamiliar with anxiety or find it inconvenient. Now, what if your request is denied or ignored? You don't have to stay silent. If the interactive process isn't followed, or if you face retaliation after making a request, you can file a complaint with California's Civil Rights Department. You also have the right to speak with an employment attorney to explore your legal options. You can reach out to us at hi@cdvlawfirm.com for a free consultation. We don't charge for reviewing your case or giving you advice. We speak both English and Spanish. Before we wrap up, let me give you a few more real life examples of reasonable accommodations for anxiety that are commonly approved. Flexible start or end times to avoid triggering commutes, telecommuting options, even part time, extra breaks during the day to decompress, reassignment of minor tasks that cause high stress when possible, private space for decompression or therapy calls, allowing a service dog if it helps manage panic or anxiety symptoms. These kinds of changes can make a world of difference, and they're fully supported under California law, as long as they're reasonable and don't cause undue hardship. So here's the bottom line. If anxiety is making work harder for you, you have rights. California's FEHA law protects your ability to ask for support, and your employer is required to take that request seriously. Don't let fear stop you from getting the help you need. Advocate for yourself. Use the steps we discussed, and if you hit roadblocks, don't be afraid to reach out for legal support. If this video helped you, share it with someone else who might need it. And if you have questions or want me to dive deeper into any part of this process, let me know in the comments. Thanks for watching, and take care of yourself. You deserve a work environment where you can thrive, not just survive.